Well, hi, and welcome to my segment in grooveu's Woodshed series. My name is Pat McCarthy, and I teach music law and music rights. That is to say, the rights associated with publishing music here at grooveu. And I'm going to start here by saying what I always start my classes with, or when people I know meet me and they say, "Oh, you're a sports and entertainment attorney," and I always respond that it sounds sexier than it is. And I think it's really important to unpack what I mean by that. What I mean by that is there is no body of law called music law. It's really a very broad collection of what's called agency law, what's called business associations, contract law, constitutional law, property law, and property law is state property law, federal property law, and certainly even international property law. It includes intellectual property law, and again, state, federal, and again, international intellectual property law. It includes employment law. It's something called the UCC that is Universal Commercial Code. Article 2 of the UCC is sales, and Article 9 is consumer financing and secured transactions. It includes tax law, again, state, federal, and international. And it includes estate planning, including succession planning. And you have to stop and think, how can that be associated with music law? But if an artist dies, who takes control of his copyrights or her copyrights? That's succession planning. Or who takes control of a business? A lot of musicians, I'll give you a very good example. Elvis Presley in his estate makes more money than he ever did living after he's died. So that's succession planning. So first I'm going to say here, my plan is to discuss each one of these with you and hope that it's an overview. It's important to know that this is not legal advice, and you should not rely on what I say here as legal advice. You should always consult an attorney if you need legal advice, and they can advise you specifically. So first, let's talk about agency law. And I know it's frustrating. All you want to do is learn about music, maybe the music business. And people say that all the time. Why do you lawyers have to complicate everything? But at its core, music is a business. I mean, maybe that discussion is better had by the accountants regarding business. I will say, and I think it's an interesting story, when my daughter was a young 5-year-old, and she is now a lawyer, she had a friend named Maddie Lauer, who ironically is in the music business, and she and her friend Maddie would go out and they would sit out on the curb and they would sell Kool-Aid. And after the cost of ice and water and sugar and the poster board that they said Kool-Aid, 50 cents, they made maybe $4.50 for a day's worth of work. And I like telling this story because the year that they did that, they made over $4.8 million more than the Chrysler division, the Chrysler Motor Company made. So, I mean, I want to put business in a context, and you think, gosh, they only made a couple bucks. They made $4.8 million more than Chrysler did that year. But again, that's a conversation for a different time and probably an accountant rather than a lawyer. But it's important to know that at the core of a business, the music business, and I don't want to make it so simple that it's cost of goods sold, revenue, profit. It's not. But we're going to discuss business associations right now. There's a corporation. So Chrysler is a corporation, and a corporation is made up of shareholders. And those shareholders divide up the cost of running the company, and they share in the revenues and profits of the company. Lot of laws outlining the rules and performance of corporations, but the simple thing to keep in mind here, and particularly in the context of the music business, is that their profits, there's double taxation going on. So the corporation makes a profit, and that profit is taxed. That revenue is taxed. And then they pay the dividends or the profits to the shareholders and the employees' income, and then that's taxed. So there's alternative forms which most musicians and frankly most businesses these days have adopted. And one of them is an S Corp. And an S Corp is a pass-through entity. It'll be the first pass-through entity we talk about, where the corporate proceeds or revenues are not taxed. It's all passed through to the dividends, so it's taxed once. The revenue profits aren't taxed, and then the dividends are. It's one pass-through. There's partnerships, and I think the legal definition of a partnership is two or more people engaged in the activities to create a profit. So there's sole proprietor, which is pretty self-explained. And then there's these things, they're state designations called limited liability companies, LLCs, limited liability partnership, limited liability professional partnership. And those also are pass-through entities. It's interesting because the federal government does not recognize a limited liability company. What does that mean? Your federal income tax does not recognize an LLC. It's a state designation. And frankly, the states do it because they wanted to attract businesses to be in their states. And the state of Delaware actually created this kind of pass-through entity, and all these corporations were going to Delaware to set up for this tax advantage. So the other states followed and set up LLCs. They're taxed as a partnership. So when you do your income tax return, you do it as a partnership, and the federal government recognizes that. So the next element that I want to talk about, and I think it's important to know that in the music business, say, well, why do I want to be a limited liability LLC? Well, certainly the pass-through benefits of paying your taxes once and not twice is significant. But it's really to limit your liability. In a corporation, in an S Corp, in a limited liability corporation, you cannot personally be liable for the tortious activity of the entity. What tortious activity? The damages caused. Well, what does that mean? And here's how I tell the story. There was a plumber who in Columbus, Ohio, a couple years ago, handed the keys to an employee of his, and that employee, who had 10 DUIs, had spent time in prison for DUIs, took the company truck and he stopped at a bar and he got hammered, and he was driving home and T-boned a family of 4 in a minivan, and it was criminal. The guy didn't even have a driver's license. It had been suspended. But more important, he went to prison for 10 years for vehicular manslaughter. The plumber, the owner of the plumbing company, lost everything. They took his house, they took his revenue, they took his 8 other trucks, and the reason is his liability was not limited. What does that mean to a band? Well, in a big sense, if the tour bus T-bones a minivan of a family of 4, that multi-million-dollar artist does not want the lawsuit of that family to reach his personal assets. And that's why very, very large, very, very successful artists, not just musicians, create LLCs to build their brand and to build their music and to make their art. So it is not uncommon for successful bands that are going to sell out, the Nationwide Arena here in Columbus or Madison Square Garden in New York. It's not uncommon for them to have multiple LLCs. And what people in business will say all the time is they want to put a bunker in a bunker in a bunker in a bunker. And what they'll do is they'll have their merchandise is sold through a separate LLC from their transportation LLC, from their publishing LLC, from their recording LLC, from their studio LLC, and on and on and on and on. So that if the tour bus causes damages or there's a liability because of infringement or who knows what, it also insulates the other components of their business. I hope that makes sense. The next item up is agency law, which is very simply stated. It's in business, it's called agency or master servant, and that's that the employer is responsible for the employee. And where it comes up all the time is employees. If an employee goes out to a vendor and contracts with a vendor to deliver a truckload of bananas to the employer's office, and the banana vendor had what's called apparent authority, thought this employee had the authority, that employer is responsible for that contract. And that's a really oversimplification of agency law. But the biggest separation between agency, and it happens in the music business all the time, is are you an employee or are you a contractor? And it's a huge difference. So, for example, this person is a contractor. He's not an employee, and he goes to the vendor and says, I need a truckload of bananas delivered to our venue. And the banana vendor delivers the bananas to Madison Square Garden the night of the show. And now the owner of the show or the owner of the band or whoever says that there is no apparent authority. He's an independent contractor. He's not my employee. Therefore, he's liable for that contract. So a lot of times you will get companies formed, very, very common in the film industry, where they'll form a company and they'll have employees, and they'll be employees for like 12 weeks to make the film. But it's really common in the music industry for you to go on tour and have 20, 30, 40, 50, 100 contractors that are engaged to be on the tour. And in Ohio, there's a 7-part test to determine if you were an employee or a contractor. And believe me, there's hundreds and hundreds and hundreds of lawsuits trying to prove that somebody was an employee rather than a contractor, because the employer has the deeper pockets. So in my plumber example, let's say that the drunk that killed the family was a contractor, an independent contractor. Now the family's suing. The plumber can't reach the plumber's assets. I hope I'm making sense. But in Ohio, there's a 7-part test, and that's the amount of time you work in a week, work processes and procedures. If I'm controlling your calendar, if I'm saying you be here at 10 o'clock, you go home at 5, if I'm furnishing the tools and the materials, here's my toolbox, you're going to do this, you're going to do that, you're going to do that. So I'm controlling your process and procedures, and I'm furnishing the materials. You're an employee, you're not a contractor. So in the music business, this independent contractor, you're going to rig my lights. And so you have to be here on Tuesday at 5 o'clock in the morning. And when you get the lights rigged, you're done. See ya. So those are the first 3: work hours, process and procedures, who's furnishing the materials and goods, method of payment. How are you paid? Are you paid a salary? Are you paid on the hour? If you're sending me an invoice, if I'm paying you a salary over the course of 12 weeks, you're an employee. If the work performed is performed outside the employer's regular business. If the contractor has expenses and can incur a profit or loss. whether there's a significant investment in the business and the contractor is not merely providing labor. Those are the 7 tests in Ohio. I'm going to really skip through the UCC, but the Universal Commercial Code, very complicated. And so there's a ton of rules that control sales. What is a sale? How is a sales made? What is a consumer sales? There's laws that control all that, and you have to conform to them. Article 9 is consumer financing and secured transactions. Whoa, when is a band ever going to be in secured transactions? Well, if you're going to go out and you're going to buy, and believe me, bands finance their speakers and their boards and their drum kits and their guitars and their mixers, and that stuff's expensive, and they finance it, and the financing company puts a lien on that stuff, and all of that stuff comes under what's called Article 9 of the UCC. And if you have time, go Google Universal Commercial Code and look up Article 2. It controls things like delivery and who takes what's called tendered perfect goods, who takes title to a delivery. If Macy's delivers a pair of shoes to your doorstep, they have tendered perfect goods, and they're not responsible if somebody steals it. I mean, it's really thick and confusing, but it's worth going to poke around. And so that brings you to contracts. And I always, a fundamental of contracts is offer, acceptance, and consideration. And the fourth one that nobody ever talks about is that no defenses exist. So I offer the job of painting my house. I'm going to pay you $1,000. You accept. If there's no defenses that exist, there's a contract formed. What are defenses to contract? There's a bunch, but the easiest one to understand, what would be a defense to contract? So I come to you and I say, I've got a trunk load in my car of cocaine. It's worth about $4 million. And you say, great. And you take the cocaine, you accept the cocaine, and then you never pay me. I can't go into a court of law and say they breached their contract with me because it's illegal. So the defense is actually called illegality. That's a terrible example, but you get it. There are defenses to contracts. And the definition of a contract is a legally binding agreement between parties where each party is obliged to perform the agreement to the other party's detriment, and which the law provides a remedy for the breach thereof. And one of my favorite topics is verbal contracts, because in the music business it's so common. Somebody calls you and they say, can you play at my club tomorrow night? Yes, I can play at your club tomorrow night. I need $500. I'll give you $500. A contract was formed. There are exceptions to verbal contracts, and they come under what's called the statute of fraud. And we talk about that in great length. But for the most part, if a contract requires more than a year to execute or to perform, then it's what's called in the statute, and you need to have a written agreement. Real estate absolutely has to have a written agreement. I can't just say, will you buy my house? Yes, I'll buy your house. I'll give you $100,000 for your house. Okay, I'll take it. That's not a contract. Surety bonds and marriage agreements all have to be written. Constitutional law, my favorite. How does constitutional law apply to the music business? Well, First Amendment guarantees us free speech. Do you have free speech in a song? Can a radio station play a song laced with profanity? So there are limits to the First Amendment. Constitutional law drives jurisdiction, and it drives copyright law. And it's really hard to understand intellectual property, but if I came over to your house and I took your laptop from you, said it's mine now, you would certainly understand property law. So property law in the music context, it's exactly the same thing. If you have an ownership right in the music that you created, in your original fixed work of art, it's your property. And somebody cannot just take it, just like I cannot come and take your laptop. And it's certainly a lot more complicated than that. And all of these bodies of law are more complicated than that, because there's case law, and we get into much more than that. But it gets you thinking, back to when I said it sounds sexier than it is. I know that I've particularly worn you out at this point. And intellectual property law is probably the thing that most music students want to understand the most. And we spend a great deal of time on that. Tax law, we've talked a little bit about. Estate planning, again, we've talked a little bit about. And I think that pretty much wraps up my Woodshed series. I hope you enjoyed it.